Josh Blackman and our regular professor Lois will be providing commentary after. More on introductions later. Just a couple of housekeeping things. Please sign in, even if you're not allowed to, because we want to keep active updates of attendance. So the sign-in sheet is you and approved, and then we'll pass it around and please make sure you sign in. Also, if you have any questions, here are officers. So if these are the places to look for if you have any questions. And then also, if you're not a law student, you can still join Federalist Society. Just go to fedsoc, fedsoc.org, and it's only $5 for an entire calendar year. And here is the purpose of the Federalist Society. The Federalist Society for Law and Public Policy Studies is a group of conservatives and libertarians interested in the current state of the legal order. It is founded on the principles that the state exists to preserve freedom, the separation of governmental powers is essential to our Constitution, and it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. The Society seeks both to promote an awareness of these principles and to further that application through its activities. So we're going to have James Donovan introduce us to serve.
Good afternoon. Thank you all for being here. Thank you, Sarah. I'm of the opinion that the ambition of this organization really cannot be understated.
But who will counteract our ambition?
Well, they exist, just not here. It is my pleasure to introduce Professor Josh Blackman from the South Texas College of Law in Houston. Professor Blackman has graduated from George Mason School of Law in 2009 and has worked with judges in Western Pennsylvania and in the Sixth Circuit. Professor Blackman began at South Texas in 2012 and was recognized on Forbes 30 Under 30 list in 2014. He has twice testified before the House Judiciary Committee on the constitutionality of executive action on immigration and health care. He is an adjunct scholar at the Cato Institute and president and founder of the Harlan Institute, as well as Fantasy Scotus. Professor Blackman is the author of 4 dozen law review articles, as well as 2 books questioning the constitutionality of executive orders. One of Professor Blackman's publications is the subject of today's presentation. Professor Blackman's 2016 article, Restoring the Lost Confirmation, is a critical analysis of how Supreme Court confirmation hearings have become a political fiasco. Professor Blackman explains that modern confirmation hearings have become a game of gotcha politics rather than an examination of the candidate's beliefs and qualifications. Written 2 years prior to the Kavanaugh hearings, Professor Blackman's article is strongly prophetic and prescribes a remedy for the growing ailment. Following Professor Blackman's discussion, Texas Tech's own Professor Lowy will comment on the issue. Professor Lowy has been teaching for 54 years, starting his career at the University of Connecticut, spending 38 years in North Carolina, and has been with Tech for the last 12 years. He is a partially retired George Killen Chair in Criminal Law and the editor of several casebooks on the First Amendment, criminal law, and criminal procedure. Professor Lowy coordinates the criminal law symposia at Tech and has presented several Federalist Society speeches similar to this one across the country. Both of our speakers today are recognized and celebrated experts in the legal profession, and we are very grateful to have them here today. Without formal formalities, please join me in welcoming Professor Josh Blackman.
Thank you. Thank you so much. So much we talk about in law school is about courts and what judges are doing. But we have more branches of government than the courts. And my topic today focuses on the legislative branch, in particular the Senate, and the role the Senate plays in selecting, confirming, and eventually approving federal judges. The conventional wisdom maintains that judicial confirmation hearings serve no, okay, let's try this. At one time, everyone take their food out of the wrapper because it's very distracting. So just take it out of the wrapper, all at once, go. This has happened before, trust me. Just take it out, wheel out, let's go. The conventional wisdom maintains that in their current form, the confirmation hearings serve no meaningful purpose. Nominees are interested in being confirmed, so they refuse to answer any questions that could jeopardize their prospects. Instead, when they get a tough question, they equivocate, they obfuscate. These prospective judges are trained by so-called murder boards to provide answers that are designed to shed as little light as possible on how they'll behave once confirmed. About 20 years ago, a prominent legal scholar described the confirmation process like this. She wrote, "When the Senate ceases to engage nominees in a meaningful discussion of legal issues, the confirmation hearing takes on an air of vacuity and farce, and the Senate becomes incapable of properly evaluating nominees or educating the public." Who was that scholar? Her name was Elena Kagan. She was then a law professor, and she criticized it. Now, Kagan was very astute. And 2 decades later, when she was nominated to the Supreme Court, she did the exact same thing, right? She dodged and bobbed and weaved. Now, why has the process come this way? It's often said that the dysfunctional state of our hearings stemmed from Robert Bork. You may recall, before I think you were all born, President Reagan nominated Bork to the Supreme Court, and Bork made the cardinal sin of answering their questions. And he articulated his own view of the Constitution. And the Democrats in Congress did not like that view of the Constitution. Right? But I take a different lesson from the Bork hearing, and this is based on an article I wrote with Randy Barnett at Georgetown. The sorts of questions that were asked of Bork were about legal results, right? What result does your methodology reach? What will your methodology mean for abortion, criminal rights, voting rights, free speech, right? Everything is about the results. And judges, at least, aren't supposed to be thinking about the results when they decide a case. They're supposed to think about the law, right? The reasoning. So long as a judge tells a senator, I will give you what you consider a happy ending, right? Will lead to a happy place, they're fine. But if the prospective judge gives the senator something that leads to an unhappy place that they don't like, it becomes very controversial. So what Randy and I have proposed is perhaps a different way of gaining insights into how nominees understand the Constitution. Instead of asking about the results, right? What result does your reasoning lead to? Ask them about their methodology. Specifically, how do you interpret the Constitution? Instead of asking, do you agree with this case or do you disagree with this case? You can ask them, what's your opinion on the original meaning of a given provision of the Constitution? And instead of asking about current issues that really they're not going to answer, ask them about old cases, right? Ask them about, maybe the slaughterhouse cases, right? An old case doesn't really matter, but gives you an insight to the window they're thinking. And if you shift the ground from questions that they won't answer to questions that they can answer, we think you'll get more insights. Now, my friend mentioned that our article is prophetic. I wouldn't go that far. But during the recent hearings with Justice Kavanaugh, I can tell you there were some questions that sounded really familiar from Senators Mike Lee of Utah and Senator Ted Cruz of Texas. And they seemed to ask some of the certain questions that we were pushing and nudging. So I think even if you have a couple members on the Senate committee that ask these sorts of questions, it will shift the training and it will force the prospective nominees of both parties to at least be conversant in these sort of historical topics. And I consider that a victory, right, if nothing else. All right, so let's talk about what Randy and I call 3 moves, right? These 3 moves. Candidates are trained to behave in a very certain way when they're asked a difficult question. And it's almost like following a script, right? The same way if you're preparing for a moot court, you have your points down, and if the judge tries to throw you off, you try and get back to your points. So the first move, right, move number 1, is to profess fealty, loyalty, to the text of the Constitution and to its original meaning. They all do this, right? If you're Sotomayor, if you're Ginsburg, doesn't really matter. They say we are professing loyalty to the text of the Constitution. They'll also say they are appealing to the general principles underlying the text. What those principles are, is a little bit more wiggle room. But they always say we start with the text. They always admit that. Because they say, you know what, we're not going to start with the text, they'll be laughed out of court. Okay. But the second move is important. They profess loyalty to the text, and they profess fealty, second, to stare decisis. Stare decisis is a commitment to legal precedent, right? Now, as we all know, a lot of precedents are not based on the text of the Constitution. A lot of precedents have no bearing on the original meaning of the Constitution. So there's an immediate tension. Move number one, I stick with the text. Number two, I stick with precedent. What do you do when the precedent might conflict with the text through the Constitution? Aha, here's move number three, right? When the senator asks the judge to apply a court's precedent to a controversy that's of most concern, the nominee invokes the so-called Ginsburg rule. They decline to answer on the ground that the issue may come before the court. Now, I think this is actually a sensible rule for the most part, and I mean this sincerely. If judges indicate how they're going to vote at a hearing, I think they have to recuse themselves where the case come before them. I think that's it's a basic principle, right? You don't want a judge to telegraph in advance his or her opinion on a given topic at the hearing, because then you know it's not a fair shake, right? You know his or her mind's already made up. Now, their mind's already made up, we know that, but they made it public. So I think there's nothing wrong with the Ginsburg rule in the abstract. So what Randy and I tried to do was to think of different ways to get to the same information without asking an unfair question, right? Without asking a question that I think can't be answered, right? So we suggest a pivot, right? The Supreme Court hearings don't have to be about nothing. This is not like Seinfeld. They can focus, instead of the cases of the court, on the clauses of the Constitution. And these hearings can focus on not just the results of a given case, but also their reasoning. Okay, so let's think of a simple change, right? Instead of asking a candidate, do you support Roe v. Wade? We know what they're going to say. It's precedent, it's settled law. Do you support D.C. v. Heller, the Second Amendment case? Of course I do, right? They're going to say the same thing. They're not going to do this, right? Give you an example. In 2009, Judge Sotomayor had her confirmation hearing. She was asked, is Heller settled law? Yes. Less than a year later, she voted to overrule Heller in McDonald, right? Barely a year elapsed, right? So these questions are not going to go anywhere. They achieve nothing. So they have a couple different questions. They're saying, is Heller settled law, which they're not going to get a good answer. Does the original meaning of the Second Amendment protect an individual right to arms? More obscure. What was the original meaning of the Privileges or Immunities Clause of the 14th Amendment to include the right to bear arms? Harder question, right? Did the 14th Amendment incorporate the Bill of Rights? And if so, how and why? Don't just tell me what the Supreme Court said, look at the history. Does the Necessary and Proper Clause delegate authority to Congress so long as its exercise is convenient for the legislature? Does the Ninth Amendment protect judicially enforceable unenumerated rights? Hard one, right? Where in the text of the Constitution is the spending power, and what limits does it have? You can answer all these cases without referring to, you can answer these questions without referring to any cases. Now, they say, this case, that case, no, Senator, I'm not interested in cases. Tell me about the history of the Constitution. And that will put them in a very tough spot because they may not know what to do. Right? Again, don't ask them how these clauses may be applied in a given case because they're not going to answer the question. They can ask themselves, are you bound by the original meaning of the Constitution? Right? They'll say, oh, that's our starting point. Say, okay, fine. What else do you use beyond original meaning? If you ask these sorts of questions, you can push them out of their comfort space. You may not even get a useful answer, but it'll make them a little bit uncomfortable. We also write that the senator should ask questions about cases that seem completely resolved, because this gives a window into the judge's philosophy. For example, a senator could ask whether we, the people in the Constitution, included slaves. That's a tough question. I have an answer. I think I could resolve it. Right? Lysander Spooner and Frederick Douglass thought it did. Dred Scott, Chief Justice Taney said it didn't. Right? Give us your understanding of history. That's not a live question. That question will get us much further than asking us about Dred Scott and Brown v. Bork, because we all know what they're going to say. We love Brown, we hate Dred Scott. But actually go through the history of who are we the people? How do we understand what that phrase means? And this case is not coming before the court. They can't dodge it with move number 3. Now, I don't think these questions are unfair. I think they're challenging. But if someone wants a lifetime confirmation to a federal court, they should have some difficulties. It shouldn't just be a walk in the park and repeating the exact same script that the predecessors repeated years before. Okay? There's also possibly another benefit. If one judge comes up and stumbles with these questions, you can be sure that the next nominee will prep, right? If one judge has an embarrassing slip-up, trust me, the next one will be ready for it. About a year ago, there was a nominee to the federal court in D.C., and he was asked some questions that I thought were fairly easy. For example, like, what's voir dire? Or voir dire, as they say in text, right? What's voir dire, right? He was asked for some of the rules of procedure, and he had no idea. He wasn't a litigator, and he looked a little bit foolish. I can assure you, every other nominee knows what voir dire is, right? They know what these federal rules are. So if you catch one judge with his or her guard down, I think it helps. And I don't even think you need to have a full complement of originalists on the committee. We have a couple. We have Ted Cruz, we have Mike Lee, we have Josh Hawley, right? Former John Roberts clerk. I think the 3 of them could handle it quite well. Now I want to talk a little about the most recent confirmation hearing. No, not the second one, the first one of Justice Kavanaugh. It might be a topic for another day. 1.0 Kavanaugh, right? Before the beer, right? And Justice Kavanaugh made a number of comments about textualism and originalism I think were fairly revealing. I'll walk you through his statements. He said, "My judicial philosophy is straightforward. A judge must be independent and must interpret the law and not make it. He must interpret statutes as written. A judge must interpret the Constitution as written, informed by history and tradition and precedent." Okay, that's pretty boring, right? That's move 1 and 2. You got text, you got precedent. It's pablum. He also made comments about being an umpire. Just give me a break, right? But then Mike Lee, the senator from Utah, said, we have originalism. It says, textualism applied in the constitutional sphere with an eye identifying the original public meaning of the Constitution. And Senator Lee asked, are you an originalist? Right? Are you now, or have you ever been an originalist? Kavanaugh said, that's correct. Let me tell you something. When John Roberts was asked the same question a decade ago, he says, I don't like labels. I don't like labels. He was telling us what he really thought, right? He rejected the label of originalist. We've come a long way since 2006 when Roberts had his hearing. So now you have Gorsuch and Kavanaugh both saying, yeah, we're originalists. And that itself, I think, is momentous. I don't think they could have done that a decade ago. The movement just wasn't where it is today. Now, whether that makes any difference in their jurisprudence, who the hell knows, right? But they were able to say it under oath candidly and not dodge the question, no, I don't like labels, I get a little bit of this, a little buffet, take here and there. Okay. I think more importantly, Judge Kavanaugh showed some sophistication. Historically, people described originalism as trying to figure out the intent of the framers. I'm sure you've heard this phrase. What did James Madison intend? This is an older strain of originalism that is more closely associated with Robert Bork, who I mentioned earlier. Almost all people who call themselves originalists today don't focus on original intent. This was, I think, Justice Scalia's major contribution to the world, one of many. But to shift originalism from what did the framers intend to what was the public meaning of their words. And it's a very important shift because there were lots of framers who had different intents. The northern states perhaps wanted to do one thing, and the southern states perhaps wanted to do another thing, right? But the only thing they agreed on was their text. And we can use various tools to understand what the text means. And Judge Kavanaugh, I think, recognized that in a fairly cogent manner. He didn't just make this up. He gets it. He said, there was an old school of original intent the subjective intentions of the drafters, and that's not really the proper approach. By originals, what I've meant is original public meaning or constitutional textualism, right? So he's focusing not only on the intent of the framers, but also the meaning of the words they chose, which is far more important. Senator Feinstein, I think, from California, asked Judge Kavanaugh about the Second Amendment. And she asked him about the Heller case, right? DC v. Heller. And Kavanaugh did what we would expect of him, where he says, I'm not going to talk about the case, but instead he talked about the methodology. And he made an important point. When Heller was decided in 2008, the Supreme Court really hadn't said much about the Second Amendment. There were a few cases here and there that didn't shed much light on it. And Kavanaugh said that Heller was unique because the court had to figure out the meaning of the text without the benefit of much relevant precedent. Right? Usually there's a lot of case law explaining what a given clause means, not so in the Second Amendment. Therefore, he said that both Justice Scalia in the majority and Justice Stevens in the dissent had to excavate. Think of like an archaeologist, right, digging for fossils, right? You had to excavate this history. And he walked through the framework, right? What's a prefatory clause mean? What about the right to bear arms? Did the prefatory clause merely state a purpose for which the right was ratified, and therefore you read as written? Right? Do you figure out, does the right exist independent of what's in the prefatory clause? And he walked through a lot of the steps that originalists would take. Moreover, Justice Kavanaugh was asked about the boogeyman of law professors, which is substantive due process, right? The idea that judges can take the word liberty in the 14th Amendment and say that means abortion, gay marriage, sodomy, whatever you want, just throw it all in there, right? And because it's in the 14th Amendment, states can't deprive you of it. So he was asked a question about substantive due process. And rather than just ducking, saying, I can't really talk about abortion, he actually talked about the Ninth Amendment, right? He says the Ninth Amendment, the Privileges or Immunities Clause, and substantive due process are three roads that take you to the same destination of the Supreme Court's precedents, which is protection of unenumerated rights. And he pivoted, I think, in an important way to explain how the court's Glucksberg framework about protecting deeply rooted rights is within this constitutional tradition. Okay? Now, why is all of this important? Once a judge is on the bench, right, we don't know what they're going to do. We have no idea. They always surprise us and disappoint us in one way or the other. But if the Senate takes a more active role in probing a judge's sentiments, I think it'll be far more effective. And I have a fairly radical proposal that I think would make these Senate hearings a lot better. What is it? The senators should not be the ones asking the questions. We saw with Kavanaugh hearing 2.0, they actually hired a prosecutor to ask him questions. Now, I don't think it was very effective what they were trying to do, but it got me thinking, right? What if instead of having these senators who've been out of law school 20 years asking these questions, you hire some practicing attorneys, maybe law professors, federal prosecutors, federal public defenders, people in the trenches who know what the hell they're talking about, right? Now, the senators are doing this because it makes for good YouTube, right? They get their zing in, someone tweets their zing, and then it puts them in the headlines. Okay, I guess it's valuable. But a far more valuable protocol will be if the committee yields its time to someone who knows what they're talking about and can effectively engage the senator on these issues. And I think that would do a few things, right? First, it would bring down the temperature in these hearings. They are very hostile. They are very political. And for a branch that's not supposed to be political, I think this is a very bad idea. Second, I think the discussions will be more substantive, right? Most of these senators, not all of them, don't know what they're talking about. They're reading from scripts that their staff prepare for them. And if you're a smart judge like John Roberts, you just ask a follow-up question, you throw them off your script, and they don't know what to do. Right? That's what John Roberts did. They were just running in circles around him. If you actually have a person who's competent in the material, they can deviate, right? It's like if you ask a professor a question, and he's just reading from a script, he can't answer it. But they can deviate and flow it. So I think it'll make it less political. I think it'll make it more substantive. And also, it will educate the public. And this is an important function of the Senate. You don't think about this, right? But the Senate exists not just to pass bills and to, take time building walls, whatever they do, right? The Senate exists to serve a civic role and to illustrate how our polity and government ought to function. And the current hearings, I think, don't illustrate that at all. I think Republicans and Democrats are equally guilty. I think the Kavanaugh hearings became a shambles. I mean, it was really bad. The nominee didn't help either. Taking some of the politics out of this investigation, this inquisition process, would benefit, I think, everyone. Now, no one's going to do what I just said, right? Because it's in no one's interest. The nominees love this easy road because they don't get any tough questions. They can dodge with move number 3. And the senators, well, the senators want to get on TV. They want to be in the center. But if they were serious about this process, they would actually hire people who could competently ask questions for more than a few minutes at a time, get a nice 30-minute, maybe an hour-long block of back-and-forth dialogue, the same way I'm talking to you guys. That'd be good. I have one other idea to reform the nomination process, which certainly will not get any votes, but I think it's a good idea. The Constitution says that the Senate provides its advice and consent. Right? The President makes a nomination, Senate gives its advice and consent. They're only doing half their job. They're either consenting or not, right? They don't really give advice saying, well, we think this guy's good and that guy's bad, or she's good and she's bad. They're saying thumbs up or thumbs down. Either you're in or you're out. My proposal, I think, is a bit radical, but I think it would not work. I think it's a good idea, at least. We all know there are 9 judges in the Supreme Court, and we all know there will be a vacancy at some point in the future. We don't know when, but there'll be a vacancy at some point. There has to be. We also know that the Republican Party and President Trump has put out a short list, a list of, 20-something judges, right, that he will pick from. And I'm pretty sure President Hillary Clinton would have had her own list of ex-judges. Now, Trump, I think, did a good move by releasing the list. That's a good idea. But the Senate could take some proactive action, right? Why do we need to have the vote only after the president makes a nomination? What if the Senate said, we'll give you some advice. We'll take votes on all 20 people on that list. This person gets, say, 50 votes, that person gets 40 votes, that person gets 70 votes. Wouldn't that be useful to the president to know in advance how the various senators fared? I think it'd be useful. Take it one step further. Instead of the Senate just voting on the president's list, why can't the majority party, the minority party, just bring up names saying, hey, what do you guys think of Joe Smith or Sally Smith, right? And just it's non-binding, just cast a resolution, it's a vote. Send to the Senate, and the president can take that for what it's worth. And then if the president picks someone who didn't even get a bare majority, he knows where it's going to go down. This approach would, I think, really decrease the temperature and take some of the surprise out of this process, so you know more or less what you're getting in advance. Now, why is this not going to happen, right? All of Josh's ideas are very good and they're not going to happen. There's no incentive to do it, right? Why is the Senate going to take a tough vote on someone who won't be nominated? They don't want to take any difficult votes because it might have repercussions for their political viability. Moreover, the president doesn't want to share his role in this process. Indeed, during the Bush 43 administration, I think it was Senator Leahy or Durbin, I can't remember which one, wanted to talk with President Bush about who he's going to nominate in advance, to have some sort of advice process. And the White House press secretary said, nope, president's job to nominate, not your job, get lost. Which actually might be accurate. But there are things that can be done to decrease the temperature of the current nomination mess, and it's a mess. It's not in a good place. The things I propose would help. I don't think they'll get adopted. But we're headed to, I think, a very bad spot. If during President Trump's administration, the Senate turns Democratic, and we had a vacancy, there's no one going to get filled. It's be like Garland again, right? We'll just have no nomination, no hearing, nothing. We'll just sit in silence. So we'll be at 8 seats for a while. Okay, what if President Trump wins re-election and a Democrat controls the Senate? We'll have a nomination, no hearing. So we have an empty seat for 2 years, we'll have an empty seat for 4 years. What if another vacancy arises? We're down to 7, right? I predict, and you guys can tell me if I'm right or wrong about this in a few years, that unless you have control by the president and the Senate of the same political party, we are not getting another Supreme Court nomination. It's not worth it. And why? Because the court's important. It decides really important stuff, right? If Justice Kennedy was on the court and Judge Bork was, we wouldn't have had a Bergefell. Judge Bork actually died. We would have had Lawrence, right? We wouldn't have had, Windsor, right? We would have had these really big cases that probably come out differently. And I think the branches finally recognize that this is worth fighting to the death over. So over a short-staffed Supreme Court, at which point the lower court's become a lot more important. Because if they're not getting cert grants, then the circuit courts become more autonomous. They can't get reversed as easily. And that makes the lower courts even more important, just what we need, right? The new judges coming in, and they're going to have to make final words. I'm going to stop here and turn to my Professor Lowy for some comments, and we'll take some questions later. Thank you all so much. Here, I got right here. I got you covered, my friend.
Okay, there is some. First of all, I want to thank Professor Blackman for coming here. I've been to a number of law schools, including one of your neighboring schools, UH, doing Federalist talks, although I will have to confess that unlike Professor Blackman, I am not a politically pure Federalist, and I admire the society so much for accepting me because I think more than anything else, the society is interested in debate, which I think is very helpful. Now, I certainly agree with Professor Blackman that the situation we have now is not good. I think it was absolutely disgraceful that the Senate refused to hold hearings on Judge Garland's appointment at the end of the Obama administration, although he may be right that had they held hearings, he would have been rejected because, as a matter of fact, you always reject the other guy's appointment. What I think is wrong with the system is that it should not be the other guy's appointment in the sense that judges, justices do not work for presidents. They do not work for the Senate. They are supposed to be independent. The best, although I think maybe a little over the top illustration of that, is Justice Powell, who, when he was on the court to emphasize his independence, actually refused to vote in elections because he thought he didn't want to compromise himself in any way. There is a way I think this could be done, that this could be fixed. And there was one president who sadly never got a Supreme Court nominee who knew how to do it. And that was Jimmy Carter. What he did, instead of picking his favorite candidate for judge or justice, well, he never had a justice, but for judge, for circuit court judges, appointed blue ribbon panels to give him 5 names. And he picked one of those 5 names. Didn't ask what his their political affiliation was, et cetera. To be perfectly truthful, I suspect that Carter was more apt to nominate a Democrat on the list than a Republican on the list. And in the one case I know where it was actually implemented, he did nominate a fairly politically active Democrat of the 5 who were presented to him. But to give you some clue, I'll spend some time talking about this, as to how judges don't do what the person who appointed him had maybe hoped he would do. We can go back to the early 50s in the steel seizure case, where at least some Truman appointees voted with the majority that the president could not seize the steel mills even though he declared it to be an emergency, something which may be coming up fairly soon, depending on what our current president thinks is an emergency. And then just look at the appointments of several presidents. Let's spend just a moment on this. Eisenhower appointed Justices Harlan and Stewart, who were indeed judicially conservative. He also appointed Chief Justice Warren and Justice Brennan, who were 2 of the most liberal justices ever to sit on the court. President Kennedy appointed Justice Goldberg, which seemed to be politically within his ken, and Justice White, who was one of the more conservative justices to sit on the court. Nixon appointed a couple of conservatives, Berger and Rehnquist, a moderate, Howell, and somebody who turned out to be a liberal, Justice Blackmun, no relation to our speaker, in fact, not even spelled the same. Well, one of the things that was interesting about Justice Blackmun is that his judicial philosophy evolved. He was not the same philosophically at the end of his term as he was at the beginning. Consequently, you as a senator ask a judge, what is your judicial philosophy? The answer he gives in 2019 may not be the same as what it is in 2035. It may easily change. President Ford appointed perhaps the most liberal justice on the court for much of the time he was on it, Justice Stevens. President Reagan appointed Scalia and Kennedy. Kennedy, of course, gave us the Obergefell case. And Scalia and Kennedy together were necessary to have a 5-4 vote in Texas versus Johnson, the flag burning case. I suspect President Reagan wouldn't have supported that. President Bush the first appointed Thomas, certainly conservative, and Souter, one of the more liberal judges on the court. So the plain truth is you just don't know. And let me conclude this with one that may surprise you a little bit. President Trump's nomination of Gorsuch. Last term, there was a fairly significant deportation case called Sessions versus DiMaia. This turned out to be the question was, could a person be deported for having previously committed a crime of violence? The question was raised whether the concept of crime of violence was unconstitutionally vague in regard to deportation. Obviously, President Trump wanted to win that case and have DiMaia and others like him deported. Well, the court, by a 5-4 decision, said that this is unconstitutionally vague. The 5 justices in the majority were 4 you would have guessed: Kagan, Sotomayor, Ginsburg, and Breyer. The 5th, Neil Gorsuch, which actually gave me a lot of joy. Not necessarily because I think the result was right, it may have been, but because it told me in no uncertain terms that Neil Gorsuch, who I did, by the way, recommend affirming, although I didn't expect that he'd adopt my judicial philosophy very much. But at least it showed me that this man is independent. He is not a handmaiden of the president, and judges shouldn't be. And I consider that good. And in order for you guys to have some time for questions, I'll stop now.
I'll say a few words and we'll take questions. That works. Thank you all so much. Yeah. Please, go ahead. I'll weave my words in.
I was just wondering, since, the goal of your suggestion was to reduce the politicalness of the Senate, or the judicial process, it just seemed to me like having the senators vote on the list previously to get more political.
Fair point. I think the advice before consent would maybe facilitate the blue ribbon approach that Professor Lowy mentioned, perhaps in a slightly different way. It would take a lot more of the drama of who the president ultimately picks, and it would give the Senate a role in actually giving advice. Now, I propose this idea not only in the context of the Supreme Court, but also in the context of the lower courts. And there's always a huge controversy of who the president picks, and then the committee votes up or down. And there may be some role for the Judiciary Committee to provide some insight in advance, not quite what Carter did, but maybe in the ballpark, that could facilitate some negotiation backdoor rather than the president just dropping his nominee. Because as it stands now, if the president has a majority in the Senate, all of his guys get through. If he doesn't, I think none will get through. I think we may actually see a point in 2020 or 22, whenever it happens, when the Senate turns Democratic, eventually it's going to happen, where circuit judges just grind to a halt. And we just don't get seats filled unless you have complete control. So,
you're assuming the president wins in 2020.
Or if you have a Democratic president with a Republican Senate, they may just say no judges, no mas. So my idea is more political in the current sense, but I'm trying to stave off what might be a really bad result where we can't confirm judges unless you have unified control. That if we get there, I think we're in trouble.
I agree.
Explain first before you define what a blue ribbon panel is.
Yeah. Well, it might include not that many people know all the places. It might include trial judges. It would probably include members of the bar who were highly respected, perhaps the president of the local state bar association. I do not recall exactly how the panel formed, but I think it was something like that. If you take the people who we recognize as leaders in the community, in the legal community, and have them do the research and come up with a study of I've always thought that was a good idea. I admired Carter so much for doing it and so much for credit that both of the other presidents and successors did not continue with that. Well, successors continued with it.
Thank you for the question. Yeah, I think both Professor Lowy and I are on more or less the same trajectory, if not exact track. If we get to the point where no one's getting confirmed unless you have unified control, I think we're in a bad spot. And I do think that's where we're headed. We're going to have maybe a 7-member court for a couple of years at some point. Yeah.
Do you think it's more likely to be like a 7-member court, or is that the psychopathic court?
Yeah. Okay. Let me address that question also. So the question, you couldn't hear it, was what are the prospects of so-called court packing or court expansion, or the new phrase is court reform. That's the new moniker. I'm sure a lot of you are familiar from your common law from 1L, studying the period during the New Deal, where President Roosevelt considered adding new justices for every justice over the age of 70. Now, he said, oh, we need to add more members because the justices are overworked, they have too much work. No, that wasn't the reason, right? He was upset that the judges were voting against progressive policies at the federal and state level. His own party rejected the court packing plan. It wasn't going to go anywhere. But I think today there's a lot of test balloons, and some people are trying to gain attention for it. Let me say it bluntly. The Constitution doesn't fix 9. It's not a magic number, right? The number 9 is set by statute. We've had 9 since basically the Civil War. We had 10 for a brief period. We've had periods with 5, with 7. It's gone up and down, but it's been pretty much at 9 for over 150 years. If you actually have one part or the other tries to just expand from 9 to 11 or 13 or 15, whatever the number is, you're now in a spiral, right? Why 9? Why not 15? Why not 25? Right? Why not have a 50-member court and draw 3-judge panels from that? There are lots of ways of approaching this. And again, I think that pushes us towards my fear of it just being completely intractable. I don't know, Arnie, what do you think?
By the way, I think 9 is probably the best number with 7 running a close second. I think you need an odd number because you don't want to have ties any more than you really want to avoid that. I think 3 or probably 5 maybe isn't enough to get full diversity of views. And 15, I think, or maybe even 11, would give you too much cacophony and not enough difference of opinion. So I think you need enough to have, to use the word that's in vogue these days, diversity, but you don't need so many that it'll take forever to decide and you really aren't gaining anything by the additional number. And I think 9 is probably right, and if it weren't 9, 7 would be my second choice.
What would you think of happen if, say, Party X, don't give it Republicans, Democrats, expanded to 15? How do you think that would affect the perception of the court going forward?
I think it would indicate that that it was more political than we wanted it to be, and that judges work for presidents and not for the people themselves. We'll comment briefly. Actually, I didn't know what you were going to say today. The article they gave me was a different one.
Oh no, I'm sorry.
What I read when you were talking about how the president can get more appointees is for members of the Bush appointees in the circuit court to announce their resignation in advance, and I was very prepared to hit you on that. That I think
you can do it.
I think that implies that judges are Republican judges or Democratic judges, and I don't think they are. I think whatever they were before they were appointed, they stripped their philosophy after that. And it goes both ways. There were people who criticized Ginsburg for not retiring while Obama was president. Not that he would have gotten an appointment anyway, but I think that's entirely wrong. Ginsburg is not a Democratic judge. She's a federal judge for the people who happen to have been appointed by a Democratic president. And I'd say the same for circuit judges.
Good. Other questions?
There's another class coming in, so we have time for one more question.
Oh, now comes the wrapping paper again. Anything else? All right, thanks, Arnie. Appreciate it. Okay, thank you all so much. Very good. I'm sorry they gave you the wrong article. I'm sorry they gave you the wrong article.